Greetings to the viewers of the KCGC television. Myself, Dr. Divya Sharma, working as Assistant Professor in the Khalsa College of Law, Amritsar. Today, the topic which I have chosen is from the Civil Procedure Code 1908, that is res judicata under section 11. But before proceeding with this topic, I would like to give you introduction about the procedure laws. Broadly, we can divide the law into the two categories: civil and criminal, and substantive and procedure or adjective law. Another name of the procedure law is the adjective law. Substantive law is that law that defines the rights and liabilities of the parties, whereas the procedure law deals with the means, machinery, and the methods to achieve these rights and liabilities. Substantive law is end in itself. It's the end in the administration of the justice. But the procedure law is the mean by way of which we reach towards that end. That is, we fulfill the substantive rights of the parties. Now, to give the various examples of the substantive laws, like Indian Penal Code, Transfer of Property Act, Indian Contract Act, Sales of Goods Act, Partnership Act are some of the examples of the substantive law. Now, talking about the procedure laws like Civil Procedure Code, the Civil Codes Act, Indian Evidence Act, Criminal Procedure Code are the examples of the various procedure laws. Proceeding further, now I would like to tell here how we interpret the procedure laws. Procedure laws should act as an aid to the interpretation of the laws. They should not act as an obstruction into the aid of the justice. Supreme Court of India has rightly stated in one of the cases named Ghanshyam Das versus Dominion of India that procedure law has to act as a facilitator in the administration of the justice. Hyper-technical view should never be adopted while interpreting the procedure laws. A liberal interpretation must be given when we are talking about the procedure laws. Justice V.R. Krishna Iyer has rightly stated that we are here, that is the judges are here, to administer the justice to the people and not to end the justice by adopting the technicalities which has been given into the procedure laws. And further he stated that the procedure laws are handmaid in the administration of the justice. Procedure law is not a tyrant but a servant. It's not a mistress but a lubricant in the process of the justice. Talking about some of the historical aspect of the Civil Procedure Code, on 1st July 1859, till that date, there was no uniform civil code in India. Slowly and gradually, the need was felt that there must be a comprehensive code that deals with everything related to the procedural matter into the context of the civil laws. And that's why in 1908, this exhaustive code came into the existence. But still, there were certain flaws in this code and major amendments took place in the year of 1976 into the Code of the Civil Procedure. The object of the code is to consolidate and amend the laws relating to the procedural laws of the courts of the civil judicature. Talking about the scheme of the code is divided into the two main parts. First is the body, that is the main part of the code which contains 158 sections, and the other part, that is the second part, which is the first schedule, that contains the 51 orders and several rules under this first schedule. The main body part, which contains 158 sections, they contain the rules of the jurisdiction of the court. They are the substantive in nature, and the main point of all these sections 158 is that they can only and only be amended by the legislature, whereas the orders, that is the 51 orders into the CPC and the various rule under those orders, can be amended by the High Court as per the exigencies of the local conditions of that area. So this is all about the introduction of the procedure law. Now Coming specifically to section 11 of CPC, that is about res judicata. In simple terms, res judicata means a case which has been finally heard and decided by a court of the competent jurisdiction. Section 11 says that no court shall try any suit or issue in which a matter which is material and substantial in nature has already been decided by a court of the competent jurisdiction between the same parties or the persons litigating under them into the subsequent suit. It means on the same facts, on the same basis, the same parties or their same legal representatives or having the same title, the parties cannot go to the same court again and again. Res judicata is a universal principle which is based on the principle of rule of law. Res judicata is particularly based upon the three legal maxims. The first maxim says that no person shall be vexed twice over the same cause of action. This is based upon the concept of the private justice. The second principle says that it is in the interest of the state that there must be an end to litigation. This is based upon the concept of the public justice. The third says that the decision given by the judges must be respected as the correct decision. This is also based upon the concept of the public justice. These three maxims want to emphasize on this issue that there must be finality to the decisions which has been decided by the court of the competent jurisdiction. Otherwise, if the decisions are not given finality, then one party will always harass the other party. There will be never an end to a litigation. There will always be a chaos and law will never be in a position to attain the finality. Justice Chandrachud has rightly said that the principle of res judicata is based upon equity, justice and good conscience. And sooner or later, the litigation must come to an end. In the case of Daryao Singh versus State of UP, Supreme Court of India has rightly said that principle of res judicata is not so technical as we think, though there is one technical concept in it, that is the principle of constructive res judicata. But despite of that, it's a very simple process whose purpose is to attain finality of the decision and there must be an end to the litigation. There are total 8 explanations that has been attached to res judicata. Due to the paucity of time, it will not be possible for me to explain each and every explanation in detail, but I will try to give it in a gist. Like explanation 1 talks about the former suit. Former suit is that suit which is decided prior to the other suit, though we are not here concerned with the date of institution. I would like to give an example. Suppose a person has filed a suit on 1st January 2022. The same person has filed another suit between the same parties on the 5th of January 2022. Now, as per the explanation 1, what will be the former suit? That will be which has been filed on 1st January. But if the suit which has been filed on the 4th January is decided, suppose on 5th of July 2023, and the suit which has been filed on 1st January 2022 has been decided on 5th of November 2023, then the former suit will not be the suit which has been instituted on 1st January, but that is the 4th January suit will be considered as the former suit. So we are here concerned with the date of decision and not the date of the institution. Second explanation talks about the competency of the court, that the court shall always be considered to be competent irrespective of the fact that any right to appeal is allowed from the decision of that court or not. Explanation 3 of res judicata talks about the questions which are directly and substantially in issue into the former suit will operate as a res judicata into the subsequent suit. Explanation 4 talks about constructive res judicata. The issues or the question which might and ought to have been raised into the former suit is considered as the issues directly and substantially in question. Explanation 5 says that if anything specific relief has been you have asked in your plaint but that has not been specifically granted by the court, it means that has been denied. And that question cannot be taken up again into the same court because the principle of res judicata will apply. Explanation 6 is known as by the name of the representative suit. And every person who is litigating under the representative suit will be bound by the decision, and the doctrine of res judicata will be applicable on each and every person under the concept of representative suit. Explanation 7 says that the doctrine of res judicata is also applicable on the execution proceeding. And last explanation says that if a case has been heard and finally decided by a court of the competent jurisdiction, but that court is a court of the limited jurisdiction, then later on if you file the case into a court of extensive jurisdiction, that will also operate as the res judicata. Now, the last point which I want to cover here is that the principle of res judicata is applicable on all the writ petitions except the writ of the habeas corpus. It means if the High Court has refused to give the writ of habeas corpus, then a fresh petition can be filed under Article 32 of the Indian Constitution into the Supreme Court. But the other writs, that is mandamus, certiorari, prohibition quo warranto, the principle of res judicata applies. And to conclude, I would like to say that the principle of res judicata is based upon the concept of the fairness and demands that finality must be attached to the decision, that is, in trust republicate ut sit finis litium. Thank you.